Be advised, the opinions and views of the hosts and guests do not reflect those of the station.
Habulin ka ng aso.
Hindi nire-release naman ng pork barrel na useless naman.
Mga patay, papabigyan ko ng 5,000 from my... So,
Marami na nagsasabi na
Hindi. Dahil baka mangyari, lahat ng madi-dismiss, mga-hostage na lang para ma-reinstate.
Magandang gabi po sa inyong lahat. Welcome to our show, Heartbeat Live. I'm your host, Ray Rosa. We'll be together for the next hour or so. And tonight, we want to go back to a topic that we took up before because napakadami pong issues na may kinalaman dito sa usaping ito na hinaharap ang ating pamahalaan at ang kanilang mga kausap dyan sa Mindanao. Tonight, we're going to go back to discussing the issue of the GRP or Government of the Republic of the Philippines and their negotiations with the MILF. Okay, inanyahan ulit namin dito ang panauhin natin noon na si Ganoong Harry Roque, a constitutionalist lawyer, and because we want to be able to see whether there is a way out of this logjam. Alam po ninyo, naalala nyo doon sa MOA sana in 2008 that was about to be signed in Malaysia, ito'y binatikos po ng gusto ng ating Supreme Court at talagang dinown po ng gusto yung Memorandum of Agreement na yon. And sa gabi pong ito, aside from Senyor Harry Roque, ang kakausapin po natin dito ngayong gabi, kararating lang dito sa ating studio, ay wala na pong iba kung hindi si Ginoong Pepe Abueva ng dati na nating suki dito sa programa natin. But he is also a constitutionalist and he is has been involved in constitution making. So alam niya ang tadhana or history ng konstitusyon ng ating bansa, whether that is 1986 or 87, and as well as the ones of 1972 or 73, no?
71.
So, or 71, at pati na yung 1935, kabisado mo na rin.
Hindi ko nabutan yun.
Hindi mo yung nabutan, pero you know very much about it. So I want to welcome our two guests tonight to our program. I was just beginning to tell our viewers that there are certain areas that are very, very troubling to me that I think need to be addressed for us to find somehow a method of dealing with it. The first thing that we want to discuss is the issue of, for example, the need for consultation. In the previous EO number 3 that was issued, and this was something which the Supreme Court also criticized very severely, and ruled on that the ones who are the members of the GRP violated grossly in terms of the provisions of the Constitution was the consultation on matters that affect public interest.
But the Supreme Court was wrong on that.
You're saying that the Supreme Court was wrong. Good. We want to hear why you say the Supreme Court was wrong.
Well, what was considered was a memorandum of agreement. It's a draft. They did not conclude. They did not sign any agreement.
No, the issue of whether the agreement was signed or not, although they say it was initialed by both parties, it was the signing was a formality. But the Supreme Court also dealt with the issue of whether that's justiciable, even if the government side was saying the issue has become moot and academic because the government said we're not going to sign it, we're not going to go through with it.
No,
and the Supreme Court said no, it is proper issue.
Father Bernas, who is the constitutionalist, said it was just a view, and it should have been just a view or an advice. It was premature to declare it unconstitutional.
Well, I am sure that a lot of people probably agree with Father Bernas, but there are also a lot of people that disagree, and obviously the Supreme Court, when we study the balance of the views expressed in the decision, did not agree with Father Bernas. But I respect your right to disagree with the Supreme Court. No? No. So the question here is, if that is the standing rule now before the Supreme Court, is that it needed consultation. The question that comes up is, from a practical standpoint, if you're negotiating with another group, how can you possibly consult the people about things that can get derailed in the negotiations? In other words, they would want the negotiations with a certain element of privacy before the details are revealed. So is the answer there, Attorney Harry, is the answer there, sana bago magpipirmahan sa Malaysia, pinag-usapan at binigyan muna ng malaking advice dito kung ano ang mukhang napagkasunduan, at least in terms of the memorandum of agreement, prior to having it signed in Malaysia at that time. Anong tingin mo doon, Attorney Harry?
Alan.
Alan, what am I calling you, Harry? I'm getting an identity crisis here. Our guest is Attorney Alan Pagya, who is a constitutionalist.
Well, with all due respect to Professor Abueva, I think the Supreme Court acted in the best interest of the Republic when it prevented the signing of the MOAD on the grounds that it stated in its decision. Had it not issued that ruling, the MOAD could have been signed, yes. And it would take another process to invalidate it. So I think they most likely took it as an opportunity and as an exceptional circumstance to avoid further proceedings or duplicity of proceedings.
Okay. Well, the language that the Supreme Court used there, addressing it especially to some of the people involved in the negotiation, was rather severe. But let's assume that wherever you stand on that issue, if you are entering into a negotiation with a group, how can you possibly continue to inform everybody in the country about what's going on in the negotiation when that's a tug of war? You know, you give a little, you take a little. Marami kasing nangyayari sa negotiation, no, na pagka binunyag mo sa publiko agad, walang mangyayari. It might derail the negotiations, and it might, kasi ang pinaglalabanan dito what price glory in order to achieve peace? What is the price that the country is willing to pay in order to achieve peace? Now, of course, the other question is, will it really bring about peace? Or is it going to be simply a prelude to something else? And I think this is the one issue that a lot of people have got to look at. Anong tingin mo dito, Kapepe? Do you believe that the MILF really have given up their desire for independence?
Well, they have declared so, and before that the MNLF. And they also know that the OIC, the Organization of Islamic Conference, would not support any secessionist move.
So is it a question of granting them the rights and privileges of statehood, in fact, if not in name?
Well, what they're asking is, quote, is sub-state.
What is that supposed to mean?
Well, my understanding of a sub-state is that in a federal system, for example,
bago nga pala lahat, papaalala ko lang, Kapepe, sa mga nakikinig sa atin, kasi si Kapepe was one of the principal supporters of a federal system. If we had a constitution, change in the constitution, you were advocating a federal state rather than a unitary state, no?
Yes. Well, but a federal state in a future time. We are not rushing towards federalism.
You were suggesting
but we are proposing regional and local autonomy.
But you were proposing a 10-year transitory period.
Well, those were very tentative ideas as to when, how long the transition should take place, and under what conditions the transition should take place.
Okay.
The important thing is this argument that